Structuring Thought podcast. We're going to go through today and talk a little bit about how do you build evidence for any type of historical or different idea. Now the problem is in a lot of historical analysis, you see a lot of debates back and forth between different authors about how this type of analysis should be done. Should it be done based on the text? Should it be done based on the archaeology? Should it be done on some sociologic or empirical type of scientific looking evidence? And I think that really misses the point. It is essentially focusing on the trees and missing the entire forest. The trees are just components of the forest. We need to be able to look at a situation and be able to see a larger picture. Now, to be able to do this, we need to have some type of method to it. Why a method? Well, in structuring thought, the basic argument that we're going to be making all through these podcasts is if we have a systematic way of thinking, of dealing with situations, then we will be able to easier tell when we make mistakes, and we can go back to that component and correct it. So if we don't have a system of thought about how we even look at evidence, how can we find out where we need to make corrections? It then just becomes a battle of different debating techniques, and I like my method more than you like yours, or somebody else is really impressed with my credentials. And we want to be able to avoid that. Why? Because we want to be able to look at reality plainly and clearly. So there's so many different ways to do this. But based on my experience and training, I have a little bit of a bias towards the legal analysis method. Why? Because essentially this method of argumentation and evidence, juxtaposition, assessment, and validation has gone through millions and millions and millions of iterations in real-world situations. We know what is going on. We know when mistakes are made in the process, and it is immediately battled out. It is then reassessed over years of reassessment in the appellate process to find out whether there's a better way that that same issue could have been handled. It is tested and stressed with real-world ramifications. Does this person get the death penalty? How much more significant a ramification can you have? We test the ramifications of this process in very significant ways. And the system is stressed far more than any simple debate between professors in a conference. So to be able to do this, we don't necessarily want everybody in the world to become lawyers. That's not really going to solve the problem. But if we do have a general understanding of how legal argumentation is put together and where its strengths and weaknesses are, then we have a system that we can attempt to follow, and we can test whether or not this makes sense with a particular discipline, whether it be in physics, whether it be in history, whether it be in English Lit. We can always come back and look at very distinct components. But first, we have to see the components. We have to be able to label them. We have to be able to assess them. So we're not going to do all that today. Instead, what we're going to do is play the general rule of structuring thought. We're going to look at a general map. We're going to get a sense of the bigger picture first, and then we'll come back and deal with details when they become relevant to our larger discussion, debate. So, okay, let's get started. The first thing you have to understand in legal analysis is there are always two sides to the equation. Now, they'll be called in a court of law a plaintiff, the person making the complaint, having a plea. A plaint comes from a version of French, which you know as s'il vous plaît, which is to pray or to ask. So if you say s'il vous plaît, if it pleases you. So essentially you're making a request to an authority to do something that might please them. And you'll see that all over court documents. If it please the court is a common opening phrase for lawyers. So a plaintiff is making a plea in an attempt to get the pleasure, the pleasing point of view of the judge. The defendant is saying, no, 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 no. I'm going to defend myself against this plea, against this complaint. So in this process, you have two adversaries that are constantly nipping at each other and trying to argue that the argument that one person has is stronger or weaker on many, many different levels. And it's those levels that we want to play with today. First thing is what's the basic argumentation structure? Basically, a person makes a complaint and they have to describe the general nature of what they want. What is it they're asking the court to do? What is the story behind the argument that gives rise to the nature of the complaint? This is called background facts. This is called the underlying story. But basically, if we talk about a simple red light, green light case, if a person ends up in an accident, an intersection, and there's an argument, who is going to be held liable? The question is, who ran the red light? Did I have the red light and you have the green light? Or did you have the red light and I had the green light? So it's a red light, green light case. You're arguing about what color the light was, and therefore you know who's at fault for running the red light. So the person who makes the complaint has to step forward with a story. I had the green light and you ran the red light. And then I got injured, I went to the hospital, and so on and so forth. But the basic underlying question is, you had a duty to stop at a red light, and you failed to stop. It caused me harm, and it's your actions that caused that harm. There's more to it than that. If you go to law school, they're going to sit there and pick that whole thing apart. But for our purposes today, that'll do. You notice how I have to come through and say, you broke the law. That's the starting complaint. The request to the court is, give me money because I was harmed. I need to pay my medical bills. So when I go through and tell that story, I need to say, you are at fault. It's your responsibility for my harm. When we do that, if that is enough to say, if nothing else happened, if that story proves exactly right, I win. That's called prima facie evidence. That's first blush evidence. On first blush, the argument that I'm making looks like it's coherent, and it would explain things sufficiently for what I am accusing you of. But if there's any problem in that first blush, on second appearance, on further investigation, that's what the rest of the litigation is about. Does my first blush attempt to explain your responsibility hold up? And the rest of the whole court case is trying to tear that down. Can the defendant find a way to say, nope, you missed something? And it's layer upon layer upon layer of trying to peel back different sources of problems with that first blush argument. And right there we have the crux of the problem with so much academic debate. They're not clear on what is the first blush argument. Who has what position at first? Why is that important? Well, when you go into court, you get into huge issues of who has the burden of proof. Now, it gets broken down into two parts. Who has the burden of going forward, which is a procedural question. We'll spend a little bit of time on that, but not much, because we're not dealing with procedure in learning. We're dealing with the burden of persuasion. Who has the more persuasive story? And those are two separate things. If you have one part of what you're dealing with that focuses on what it takes to procedurally move the process forward, that becomes much more of a technical, clinical, step-by-step process. Where the burden of persuasion is a feeling, is a sense that, no, there's other things that don't really fit in. So we end up with a juxtaposition of two different ways of looking at And if you go look at my later video on Ian McGilchrist's book, The Master and His Emissary, I will end up talking a lot about the significance of how the left hemisphere of your brain analyzes things, and the right hemisphere looks at the context. And this is kind of, you can see these elements in play already. The technical is more the logic, the step forward, step by step, and the overall persuasion is much more the right hemisphere, seeing the larger context. So we're going to be dealing with a lot of these things in different videos. So for now, we need to have a first blush argument. Does it even pass the initial smell test? Could it be true that you are responsible for harming me if you ran the red light? Well, under American law, yeah, if you ran the red light and I end up injured, you're responsible. On first blush, my argument holds. Notice I didn't say I presented any evidence. I didn't have any photographs from the scene. I didn't have any witnesses saying if they saw anything. I said, here's my story. And this is so significant when you get into academic literature, because you end up with these problems of where do you start. Now let's get to the second part of this. If the case is simply a red light, green light, now we get into deeper things really quickly. The defendant can come back and say, nuh-uh, I didn't do what you say I did. I did not run a red light because I had the green light. Now we know immediately that there's an argument of fact. I'm saying I had the green light, and you're saying you had the green light. So how are we going to figure out who's telling the truth? Who has the underlying facts that support their version of the argument? So we will need to then look at all sorts of different information. And that's when you do start looking at who are potential witnesses. Who could essentially vouch for what you're saying? Did the car next to you run through the light at the same time you did? Well, that would tend to indicate that another person had the same perspective on what was going on as you did. Now, it may have been that they saw a yellow light and they were charging forward to try and get through on a red light, and you happened to be the one that had the collision. But it could also indicate that two people also perceived it being a green light at the same time. Is there a stoplight camera that could have caught an image of somebody going through a red light and triggering the camera? Well, if we have photographic evidence and there's a timestamp on it and there's a system for taking the pictures in a way that is credible, and that's a huge issue, but we'll lay it aside for now, then that could be admissible evidence. Now we're starting to see little bits and pieces that could be used to establish whether or not the case is valid or not. So how do we know what evidence we should accept? Well, first of all, it has to be germane. It has to address something relevant to the case. If I end up presenting evidence that says a UFO landed on my house, how is that germane to a red light, green light case? It's bizarre. And maybe it's not relevant because we don't believe in UFOs. But that's not why it would not be admitted into evidence. It would not be admitted into evidence simply because it's not germane to the case. It doesn't matter whether there are UFOs or not. It's not relevant. Secondly, it needs to be probative. It needs to tend to indicate that something is more or less true. It has to move the game forward. In the football analogy, it has to advance the ball or pull it backward. If it just stays still, it doesn't really do much for establishing the credibility of the case. So we also then have the question of how much is enough. And this gets to be a huge problem in terms of who has the burden of going forward, who has the burden of persuasion. If you get into civil cases, it becomes a matter of you have to say just enough to technically advance the case. So I have to be able to present evidence that shows I was driving the car. It may simply be my testimony that says I was driving. There has to be evidence that there was a red light, green light issue, and I have to be able to testify that I saw a green light. Whether or not you agree or not, I am presenting evidence of my personal observations of what happened. And then you end up with the question of harm. Well, I can present medical bills. I may have a doctor's report that essentially says what injuries I suffered. So there's all these types of evidence that I can present. If there is some evidence that what I need to say to make my story move forward, I have met my burden of going forward in a civil case. That's all I have to do. I have to be able to just get it. It's the best way to look at this is the tennis analogy. If I hit the ball back over the net and I don't go out of bounds, then I win the point unless you hit the ball back. So it's constantly a matter of, can I get the ball back over the net inbounds? And inbounds in this sense is a matter of staying within the rules. Your job at that point in time is to say, well, I had the red light, the green light, pardon me. So you're trying to hit the ball back over the net. Well, if we're both saying we had the green light and there's no tie-breaking issue, it may be stuck at 50-50. The scales of justice lay out evenly, and nobody has an advantage, except the defendant always has a slight advantage. The defendant cannot be held liable unless there's just one grain of sand more evidence in favor of the plaintiff. So the defendant starts by saying, if it's 50%, like in baseball, the tie goes to the runner. In this case, the tie goes to the defendant. It becomes important to know who wins ties. In this case, tie goes to the defendant. So I have to be able to prove, just with a slight scintilla of evidence more, that I had the green light or that you had the red light, because they're really interchangeable in this type of example. Not always, but in this case. So if we then take the next step, that just moves the case forward. Now you have to say something more meaningful. If I've done that one scintilla. Let's say my one scintilla of evidence is I had a passenger in my car that said, yes, I saw a green light, because I was looking further down the road and I wanted to make sure we were on time, so I was studying which light was green. Well, that gives me that scintilla evidence. It's not just my word versus yours. It's my word and another person who had an incentive to be paying attention to the light's color. Now, if that person's a perennial liar, you may be able to come back with your own evidence and essentially say, look, this person's been convicted of check fraud. They've been guilty of all sorts of other situations where they've been accused of perjury, so they're not really a reliable witness. Well, in that case, a judge or a jury could say, nope, I'm not accepting that evidence. So even though I presented evidence, it's now impeached, it's now questioned, it's now even potentially removed from evidence that's admissible in court. And this is where this nature of the game is. I present evidence, you either challenge it head on, or you try and weaken the credibility or admissibility of the evidence that I present. And this is where you end up with the rules of evidence being so large. Most of the rules of evidence are about when can you get evidence in, when can you disqualify it, when should it be questioned, when can it not be questioned. So, for example, there are some things that can't be questioned. A previous decision by this judge in a previous case, judgment having been entered, is taken as true in certain circumstances. You can't go back and re-argue it. The case is already closed. It's already established as a matter of law. That doesn't happen very often, but it can. Or the nature of what is the statutory law. Lawyers and judges can go straight to the statute books. They can look at what the statute is. As long as it's this edition that's current, that is what the words of the law are. No ends, ifs, ands, or buts. So you end up with notice to the court that this is the law. You may argue about how to interpret it. Does and apply here or not? Is this an or situation? Surprisingly, even though the words may be there on the page, it may have an impact on how you read conjunctions in grammar. So knowing what the law is as a matter of the words that are involved are not up for debate. It is what it is. It's this type of process where one side makes an argument, the other one then has an opportunity to attack it, undermine it, and call it into question, is so systematic. And then giving the other side a chance to provide a rebuttal to any challenges to their evidence is also important. And often what we see in academic debates is you have somebody who obtained their PhD 20 years after the debate began. So rather than going back and putting together their argument in terms of seeing how the overall argument has developed, they jump into the current state of the debate and ignore anything that preceded before. So you end up with these, what are called collateral attacks, attacks on issues that aren't really the issue. For example, with my second witness in my car being potentially guilty of fraud or perjury, you're not really attacking the person's story. You're attacking their ability to tell that story. It's collateral to the real issue of whether or not there was a red light. The person's testimony is not going to be allowed or is going to be questioned because of reasons that have nothing to do with the red light. And it's those types of collateral attacks that so clutter so much of the academic literature. And it leads to some very significant errors in logic and reasoning. What do I mean? If you have somebody who is debating whether or not a book was published 100 years before a significant event or 100 years after a significant event, if you start in the middle of the argument, you may say, hey, look, I have carbon-14 dating on this document that says that it was published 200 years later. Okay. That could be significant, but it could also be completely irrelevant. It could be that everybody has always said that this document could not have been written down in its current format until 200 years later. That's not the question. The question may be whether the document in its original handwritten version was written 200 years earlier. So the fact you have a copy that's 200 years old doesn't answer the question of what happened 200 years prior. However, if the argument is this document is the one source that came from the original author and this is the original manuscript, then yeah, 200 years later is a very significant issue. So we have to be exceedingly clear as to what the underlying debate is and whether or not this is a collateral attack or is relevant to the actual underlying dispute. And it's very, very easy for audiences to lose track of these types of things because you have to be deeply enmeshed in the debate to know what the prior argument was, what the responses were, and then how this new attack fits into the overall history of the argument. And this is often the case in creating confusion because the author doesn't go back and do a short review of the literature to that point in time. It doesn't assume that anybody in the audience is new to the issue. It assumes that the audience is all established. Now, if the audience is all established, they're all 30-year, tenured professors, and they're all subspecialists on this exact document, yeah, spending a lot of time telling that backstory may seem to be irrelevant. The problem is it may have a hidden piece of information that even the well-tenured professors miss. So, for example, if the collateral attack arises because of part of the story being wrong in one of the earliest papers, it becomes extremely important to know what the backstory is, to be able to make sense of the entire argument. And this lack of backstory tends to create layer upon layer upon layer of problem, because there's a built-in assumption that everybody knows the same backstory. But if you always start from the presumption that everybody does not know the same backstory, I mean, think, for example, if you were in the middle of a red light, green light case, and 6 months into your case, a new judge takes over the case. Yeah, they can go back and they can read all of the old paperwork that's in the file, or you can give them a one-page summary of where the significant issues in that case are. Some of the decisions they need to make don't really rely on having that much technical knowledge of all the nuances of the case. Instead, it may simply be they need to know 3 key facts, and then they can go from there. So being able to summarize a lot of information allows the new judge to come up to speed faster. And think about that. How many times in the academic literature are 30-year tenured professors, assuming they only have a 30-year tenured audience, or the ones that are newer to it wish to become 30-year tenured professors, and they're doctoral candidates right now, so they're expected to read the literature and catch up? It seems really odd. If they could have written a one-page summary of the history of the argument to that point in time, then even a bachelor's candidate reading the paper would have a better chance of getting something materially out of it. And I think here we start to see part of what my argument is in structuring thought. We are so busy focusing on details that we don't take time to lay out maps. We don't put together the larger picture first, and then say within that map where the particular detail is we want to contend with today. So we end up seeing with legal argumentation, there's inherently a map of how a legal argument has to be made. The rules of evidence say this is how the process works. Plaintiff makes the case, defendant says, no, that's not right. The plaintiff has a rebuttal. The lawyers get a chance to summarize their arguments to the court, whether it be the judge or the jury, and then it's submitted to the trier of fact, judge or jury. And they come back and they make a decision. They say this person wins, this person loses. If it's a judge, he then says why. If it's the jury, there may not be an explanation of why. It's just a yes or no. But there you have a map for how the entire argument can go. Now, that also means that both sides can then anticipate where the other's strengths and weaknesses are. And that makes for a far better debate. It makes for a far better universal understanding of what the nature of the issues are and how they can be argued. And because law is always bringing in jurors, and there's always clients that are not as articulate about the law, there is a profound emphasis on taking complex things and at key moments making them simple and understandable for a lay audience. And this is what academic literature is notorious for always avoiding. They don't take into account that a lay audience is ultimately going to be a beneficiary of the work. It's all well and good for an MD, PhD to be working on a project, and his key audience is other MD, PhDs. But ultimately the question is can a patient benefit from all this research? That's what it's all about. And if you don't set up an opportunity for a patient to be able to understand what's going on, they're not even going to choose to have the procedure done. So we always have to think about things in terms of who the lay audience for something can be and how we can make this project better. That means that we end up having to think about a complex thing in a new way, in a simple way. So by having these layers of argumentation, where you have a first blush, a prima facie argument, and you have a back and forth set of rules. Who has to hit it over the net? What is out of bounds? We end up being able to have more people follow the argument, which means that more people can contest the conclusions that are made at different steps along the way. They can then question the credibility, the probative nature of any witness's testimony. A layperson can become a greater part of the conversation. That doesn't mean that the layperson is the best person to judge a case. In fact, in a court of law, juries don't judge. They don't decide who's following the rules and who's not. But they do decide who has credibility when it's all over. And in academia, the layperson has almost no say over who has credibility. And it becomes a self-referential cycle where one academic tries to adjudicate whether or not another person is persuasive or not. They go to a conference and they go to have a jury of their peers. They go to have people of a similar background. And yet, if these same people were to take their argument in a formulaic jury-type process where laymen are the ones that are judging it, and the scientists then had to make an argument to a lay audience with both sides having their cases laid out, I'm not so sure that much of the academic debates would survive. I think a lot of what academics take for granted would be questioned. Their underlying presumptions would be questioned, they would be attacked, and a lot of them would fall apart. What they think would be a scientific method turns out not to be a scientific method at all. It's just a bunch of statistical analysis that is poorly done. And it's something you see in court all the time. Expert witnesses are attacked, their credibility is impeached, their experience is put into doubt. Their PhD does not allow them to testify. It is their personal experience with questions close to the matters at trial. It doesn't really matter if you have a degree on a subject if it's not connected to what's at issue. And we'll spend more time talking about what it means to have expertise and talk about some of the analogies to the law there. But I think it's significant to recognize that courts don't presume that a credential gives credibility. It doesn't give a warrant, a proof of germaneness, a warrant of probity, a proof that the person's argument is actually relevant to the issues at hand. So we have layers of analysis. We have this back and forth over the net. We have an out of bounds. We have a map that we want to follow. And we don't want to rely on somebody having to do thousands of hours of work to catch up with the argument. And as we go through this, we're going to see a lot of arguments that are made that violate all of those premises. So with that, I'm going to wrap up and suggest, if you can, read a story about a court case that's rather complete. I can't necessarily recommend any off the top of my head, but there's some that are out there that are kind of interesting. Not the Ally McBeal where they get in and they make stupid arguments, but things that actually follow a court case from start to finish. Sometimes the best way to do it is just to go find somebody who sits in a courtroom and gives day-to-day summaries of what happened in court that day, particularly if they have a legal background. It's going to give you a good sense of what that back and forth process could look like. Now, in conclusion, I'm going to say I'm not recommending that every argument needs to be made in a lawyerly way. I am saying that if we have this map of how an argument looks in mind, it becomes a lot easier to see when argumentation is poorly done, because we have a prototype to compare against. And we're going to see that all through the rest of these videos. We need to talk about models and prototypes and variation from those models and prototypes, because that's where we learn. We learn by separating one thing from another. And that's going to be what we're going to see in my book, Contrast in Education, where we take two different things and see, by separating those characteristics out, what it does to change our understanding. So for now, thanks for watching. This is the Structuring Thought podcast. We'll look forward to seeing you soon.